So thank you for being here, and please join me in welcoming Chief Judge Forte, who's doing a terrific job at the Family Court.
Afternoon, everyone. General Raimondo, Leader McCaffrey, Chairman Craven. The Family Court Act of 1961, which created the Family Court, explicitly mandates that all children who come before the court receive the care, guidance, and services they require and deserve. There is no mention in that enabling act of punishment. Since the very beginning, over 60 years ago, the Family Court has focused on rehabilitation, not punishing juveniles who find themselves in the juvenile justice system. The Juvenile Intake Department, by statute, is mandated to review each petition filed by law enforcement, or in the case of truancy, by a school department alleging that a juvenile has committed an offense. In 2018, the Intake Department processed some 4,000 petitions submitted against 2,565 juveniles. Over 2,000 of those petitions were successfully handled by the Intake Department informally through diversionary measures. Some 1,200 petitions were handled through informal hearings within the Intake Department, and another 1,200 were referred to the informal truancy calendars, and about 200 to the Adolescent Drug Abuse Court, which we call the Juvenile Treatment Drug Court. The recidivism rate for these youth who did successfully complete the Intake Department diversionary process is about 10%. So we've been very successful at dealing with things on the front end. Certainly since I took over as the Chief Judge, we've networked with the community hearing boards and with a lot of, created a lot of new opportunities for our intake department. We were able to collaborate with DCYF, and I thank the director specifically for her willingness to allow us to access services directly without having to file DCYF petitions. And that's been an extraordinary tool for us to keep these kids off the formal calendar. What we continue to have problems with is what the governor mentioned, which is the back end. And I find the lack of aftercare programs presents an enormous temptation and lure for our children. Once a child completes a diversionary program or a juvenile case closes, there's a real danger that the juveniles will be right back amid the toxic circumstances giving rise to their difficulties. I'm hopeful that the Juvenile Justice Workgroup will explore ways to provide more aftercare activities such as sports clubs, cultural exposure, homework assistance, counseling opportunities, and most specifically mentors to serve as positive role models. And then we'll need to get ways to get these kids to these programs, because transportation has been another hurdle that we've had to face. I'm proud to co-chair the Governor's Juvenile and Criminal Justice Workgroup and look forward to leading the group along with Judge Keogh in the important task of identifying and finding ways to break barriers adults and juveniles face when re-entering society, thereby curtailing recidivism. Society benefits when adults leaving prison have a roof over their heads and a good job, or when juveniles exiting the juvenile justice system have a good home, access to education, job training, wholesome activities, and a solid plan for their future. Governor Raimondo, I commend you for recognizing the importance of re-examining our criminal and juvenile justice systems in order to identify strategies that will grow restorative justice practices in Rhode Island. And more importantly, Governor, I applaud your willingness to take action by creating this work group. And I thank you all. Thank you.